Some viewers may find the following video disturbing. Viewer discretion is advised.
It's a case containing the horriblest of things.
Court is calling State of Texas versus John A. Dominguez. You, Mr. Dominguez?
Yes, ma'am.
You entered a plea of no contest on May 22nd, 2023 to the offense of indecency with a child by contact. According to the plea bargaining agreement, punishment is to be assessed at a cap of 10 years. There are no applications, and this is to run concurrent with the case out of Lavaca County. There's to be Chapter 62 compliance, no contact with the complainants. All right. State, do you have any witnesses?
State has no witnesses, Your Honor.
Defense, any witnesses?
No, Judge, just argument.
All
You
right.
have a chance to read the letters.
And just give me 3 minutes to read the letters submitted by counsel.
Thank you.
Let's not wait that 3 minutes. I'm sure we are all wanting to see Vader burn, this pervert.
All right, the court will hear argument. State.
Your Honor, State would like to point out, and the court has reviewed the PSI and the stipulations in this case.
Yes.
The state will just cover some of the more high points of that. Sexual abuse started when the complainant was 7 years old. She said she was forced to touch the defendant at that age. It continued and got worse as the defendant would touch the complainant's breast and pubic region. The complainant specifically recalls the defendant penetrated her at least 3 times with her penis. That the complainant, Skyland Dominguez, suffered trauma and had to go to Clarity for mental health treatment. And there are serious concerns about whether she would even be able to testify if this case had gone to trial. And that's part of why we came to this agreement that we did. Given the allegations. And so the state would ask that you meet the cap at 10 years. The allegations are very significant, and what happened and what the defendant stipulated to is very significant. And I will point out that while the complainant Skyland had to go to Clarity for this treatment because of what the defendant did to her, she said that the defendant abused her while she was at Clarity.
Somebody needs to talk to Clarity then.
And Your Honor, the state is asking you to meet the cap at 10 years and sentence the defendant to 10 years in TDC.
All right, so just a second. Are you saying that the complainant was at Clarity, which is a facility, and you're saying that somebody from Clarity allowed him to go into the facility? Is there proof of that?
That is the understanding, yes.
Is there proof of that?
That's what the complainant has said in the report.
All right, because the court's understanding is that anybody who goes to Clarity, if you're going to visit someone, even if you're a parent, you have to sign in. So is there anything of that nature? Is somebody planning on suing Clarity because they let somebody in who's charged with this offense to see?
The state is not aware of anything like that.
Okay. Counsel?
I wonder what pervert's lawyer is talking to pervert about. Perhaps it is something to do with how weak the prosecutor is for agreeing to give this thing a 10-year cap, knowing full well that he's guilty and deserves so much more for murdering a childhood. Let's hope that he's telling the perv that Vader has found a flaw in his case, so she might give him less than the 10 years and gets the pervert's hopes up.
Sorry, Judge.
Yes, you may proceed.
Oh, on behalf of Mr. Dominguez, Judge, we know that the court has read the PSI. We are understanding of the severity of the offense. However, my client, through his plea of no contest, was hoping not to have to put anybody through anything further. He has the support of his family, his mother, his wife, his son. They're all present back here in the...
This is so funny, where we have pervert's lawyer who has managed to talk pervert sicko family into coming down and showing the judge that if they can forgive him, then the judge should as well. And he would have told them that he is going to point to them when addressing the judge, so as to show the judge that pervert must be a good guy if he has these people supporting him. Since we can see that Judge Boyd is captivated by this awesome legal maneuver.
Back. He
That
He,
is why we know that he told Sikco about this plan to point as well. Is that plan not going to plan?
he's asking the court to sentence him to 7 years.
All right, Mr. Dominguez, anything you wish to say to the court about this offense and why you did what you did?
We'll take that as a no.
He'd rather not talk, Judge.
All right, you'd rather not say anything. All right. And State, you're telling me the complainant has, I'm assuming, mental health issues and some other issues.
There are issues that show.
All right, the court is going to find you guilty, sentence you to 10 years in the prison. This run concurrent, Chapter 62 compliance. There's to be no contact with the complainants. And the court will give you credit for any time served.
Judge, I'll be giving the clerk some dates from when he was in jail in Lavaca County that I believe will be entitled to as well.
Okay. All right, we can go off the record. Here's the thing. When this happens, guess what? Someone's childhood is ruined. They will never be a child again because of what you did. When you go to the prison, you need to sit there and think about it. You understand? All right. Thank you.
Thank you, Judge. No, you're excused.
Yes.
I do hope his stay in prison is uncomfortable.
See, you're not, have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself or do you wish to
Yes,
have a
sir.
public defender to represent you?
No, sir. I'm representing myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, but count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes, sir.
Or if you'll raise your right hand to be sworn in.
You're about to give the truth, whole truth, and you got the truth, so help you God.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to
No, sir.
to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing for pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
I comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, and you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
All right, I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I end up pleading not guilty.
Okay, all right, you're filing motions?
Yes, sir. I
You
got
have copies for the state?
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it, go ahead.
for my release from the Bay County Jail today.
Okay.
That's the declaratory judgment. That's for the clerk only.
Now, you're providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk. The declaratory
Anything you
judgment-
file that you want me to consider, you have to provide a copy to the state, sir. That's you're representing yourself. You have to know those rules. If you don't, you're going to mess
I
up.
understand that.
If you're not providing to the state, I'm not going to consider it.
Okay,
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're indigent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir,
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December?
19th.
December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen, all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen
I'm
to
a
me.
United States national.
If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that. So
Okay.
we'll see you
No
December
problem.
19th at 9 o'clock.
It's no problem.
That's
Oh,
enough. I don't want to hear another word.
okay. I'd like to also.
I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did.
Thank you all so very much for watching to the end. Please subscribe and drop a like if indeed you did enjoy. I hope so. Until the next time, I'm off to feed those cats. And if you want to see another cool episode of mine without all the mandatory stuff, then click on the episode on screen now